was that we are looking at assault in criminal law. And I did say that when we say assault, it's one of the non-fatal offenses. Non-fatal, those that do not involve death. And we have to understand that in law, an act may be a civil wrong and at the same time a criminal offense. So one act may be a civil wrong, at the same time it may be a criminal offense. In that case, the victim of the act may choose to sue the actor in a civil action for whatever remedy the law may afford. And the police may go after the person in a criminal prosecution at the same time. So there are instances where somebody assaults another one, then the victim will take the actor to the civil court for remedies such as compensation or damages in a civil action. At the same time, the actor will be an accused person in a criminal prosecution conducted by the police. So what you realize here is that one conduct of a person qualifies as a civil wrongdoing against the victim, and it also qualifies as a criminal offense. Does it make sense to you? Now, our purpose this morning is not to look at the civil aspects, but I did say that the civil assault is very restricted in meaning, very narrow, in the sense that it does not involve a touching of the body. In civil law, in the law of torts, when we say assault, we are talking only about creating reasonable apprehension or fear that some harm may be caused to the person. So if I raise something and I say I am going to hit you with it and I run after you, you are running away because I have created fear in you that if I reach you, I will strike you with the object I have in my hand, and that may cause harm or even death to you. So you are running because of the fear that I have created in you. And the creation of that fear is what we call assault in civil law. Does it make sense? And that is all there is to it in civil law. Now, in civil law or the law of torts, when I say I'll strike you with this, and I run after you, and I get you and strike you with the object, because my action involves a touching of your body, we move from assault to what? To battery, which is a distinct tort, a distinct wrongdoing in itself. Does it make sense? And then in civil law or in the law of torts, if I confine you or restrict your movement without your consent, it is called false imprisonment. So if you restrict a person's movement or detain a person against his consent, it is false imprisonment. And this is also a distinct tort. It is an independent, individual, separate tort. So when you come to study the law of torts, you are going to study assault as an independent tort, battery as an independent tort, false imprisonment as an independent tort. But when you come to criminal law, The word assault combines all the three. Assault in criminal law means one of three things. It could be assault without battery, assault without bodily touch. It could be assault with battery, that is assault with bodily touch. And it could be false imprisonment alone, whether with or without a touch. That is what assault means in criminal law. So we have three types of assault in criminal law. So when the prosecution is sending a person to court for assault, whether it is assault with battery or without battery or false imprisonment, the police will only say assault, contrary to section 84 of Act 29. They don't have to specify that assault with battery or assault with a battery or false imprisonment. They only say that assault, so that the evidence they will lead or adduce in court will let us know which kind they are talking about.